Hi, everyone. Sarah Parshall Perry. I'm Vice President and Legal Counsel for Defending Education, formerly Parents Defending Education. The parents are still there, but we're in higher education now. So UC Berkeley, you better watch out. Today is a good day. Today we celebrate the 100th anniversary of a cornerstone of American liberty, the fundamental right of parents to direct the upbringing and education of their children. This right, affirmed by the Supreme Court in Pierce versus Society of Sisters, stands as a testament to the essential role that the family plays in shaping the future of society and Western civilization. Pierce should be celebrated by everyone committed to liberty and individual government. In 1922, Oregon voters passed the Compulsory Education Act. Fun fact, it was backed by the Ku Klux Klan. It aimed to eliminate private and religious schools and assimilate religious parents into public education, stripping them of their right to be able to choose the best educational opportunity for those children. But thanks to the courage of its challengers, the Supreme Court unanimously struck it down, saying that, yes, the act did violate the liberty of parents to direct their children's upbringing. And in so doing, it reminded the state that it should never believe it owns the nation's children. American children belong to their parents, and parents alone are the best suited, not government officials, to make decisions regarding those children's education, moral development, overall well-being, and upbringing. Pierce wasn't just a legal ruling. It was a reaffirmation of individual liberty, rights that are parental, pre-political, natural, and existent since the dawn of civilization. Pierce echoes throughout history to this day, 100 years later. It and its progeny stand to secure the primacy of parental rights to raise our children according to our convictions. Parenting, as Justice McReynolds reminded the nation in the related case, Meyer versus Nebraska in 1923, is among the privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. But today, parental rights are under unprecedented attacks. In a few weeks, the court behind us will determine a case, Mahmoud versus Taylor, in which it will be answering the question of whether or not Montgomery County Public Schools' failure to allow opt-outs for religious parents for LGBTQ-themed curriculum for 4- and 5-year-olds was a violation of those parental rights. More than 1,200 school districts across the country hide gender identity information of minor children from their parents, many openly lying about those children's gender identity. That puts 12 million American school kids in the crosshairs between the school and the parents. The parents, we know, who know best. Washington State permits minors 13 and older to receive so-called gender-affirming care without parental input, processes that often start in Washington State community schools at their health clinics. 29 states and the District of Columbia permit sexual orientation and gender identity determinations when making foster care placements for needy children. Families pre-exist the state. They are not political entities. They are not in partnership with the federal government or the state government. Schools of any kind exist to support parents in their educational responsibilities, but they remain subordinate to parents. No Joe Biden, no Randy Weingarten, no Becky Pringle, no Hillary Clinton. They don't belong to all of us. I have the stretch marks to prove it. Woo! Let us carry forth today the legacy of Pierce. Let us stand firm in protecting parental rights. Let us always remember that a child's greatest educators, its greatest advocates, are the loving parents who guide them with wisdom, care, and unwavering dedication. Thank you.